Hi, my name is Peggy Cooney. I am a trainer and a coach for UC Davis, Northern Training Academy, and my colleagues.
Hi, I'm Larry Picard, and I'm also with the Northern Training Academy.
My name is David Myers, and I'm an attorney, also with UC Davis and Dependency Legal Services.
In the course of a single day, APS specialists often wear several different hats. We're a social worker, an investigator, an advocate, an errand boy or girl, a doctor, a Girl Friday, a counselor, an attorney, and a host of other things. We're Superman, Oprah, Dr. Gray,
For sure.
Wonder Woman, and Perry Mason all rolled into one. We spend a lot of time in the courthouse, but only a small percentage of this time is actually spent in court. In this video, we'll offer some tips on how to be court ready for social workers whose jobs do not typically involve going to court.
Going to court can be really very scary. It's a very public scrutiny, if you will, of your work, and it can be one of the most frightening parts of the job. So it's right that we're called into account, but when you're in that witness box or when you're deposed or whatever the situation may be, it may feel very uncomfortable. So we hope today to go over some of the things that will help you with that discomfort.
So let's talk court. The topics we're going to cover today is who's in the courtroom, what to expect, the big five in trial testimony. David's going to talk about 2 reasons that hearings are contested. Larry and I are probably going to talk a lot about what can social workers do. Again, all of us will talk about testimony survival tips, what to wear in court, and really paying attention to body language.
Who's in the courtroom? Well, lawyers and judges are in the courtroom, and they all have a certain way of thinking about things. Lawyers and judges first, before they even read a report or look at anything, they're always thinking to themselves, what is the law? What's the applicable law? And who has the burden of proof? There are various different kinds of burdens of proof, from beyond a reasonable doubt to clear and convincing evidence, preponderance of the evidence, and prima facie, all very different standards. And then from there, once they've made that framework, that's when they'll take the facts, which is what you'll present, and they'll take your recommendations and your analysis, and they will weigh all of that against those burdens and laws that apply to come to the conclusions that they do. So when you are testifying, there are certain elements to look at. I think even before you get on the witness stand, you will need to have a conversation with the person, with the lawyer who is calling you as a witness. That when you do testify, that's going to be called direct testimony. And direct testimony, as it was taught to me in law school, is very open-ended. It's your coffee shop conversation. Think of it like you're sitting across from somebody having coffee, and they're going to ask you, oh, tell me, what about that? And why is that? And how did you get to do that? You know, the W's, the how, all of those things. It's a very open-ended conversation, and it's really all about the attorney asking you what you know. Of course, the attorney should already know what you know, but you are teaching the judge and you're teaching those around you everything that you know. That's why you're testifying in the first place. So it's a tell us what you know, as if we're sitting here having coffee. That's direct examination. Once the lawyer who calls you to the witness stand is done with direct examination, the other lawyers are going to get a chance to ask you questions. That's called cross-examination. Cross-examination need not be cross. Well, sometimes it can be. But really, again, everybody's trying to get to the truth. Everybody's trying to get to what they know. And when we were in law school, we are taught that on direct examination, you, the witness, are the star. And as the star, you are teaching everybody what you need to know, what they need to know about whatever it is you're testifying about. Cross-examination is very different. Cross-examination, lawyers are taught that it's actually the lawyers who are the witnesses. That's, in other words, the lawyers are telling the judge or the jury, the fact finder, what they want them to know. And you're just there to be a little conduit for them. That's why those questions are closed-ended. Isn't it true that you didn't go out to the home that day? That's the lawyer saying, hey, I want everybody to know you didn't go out to the home that day. That's why cross-examination is so narrow. And we may spend a little time today talking about what you need to know and ways to kind of handle cross-examination with you as the expert. One such way is listen very closely to the question. Take a deep breath, give your best honest answer. Isn't it true you didn't go to the home that day? Yes. If you want to say something more and you want to feel like, that's not exactly true, the yes but and the no but answers won't serve you very well because the lawyers will cut you off. But you can do something. Here's a little trick. Some of the best answers you could ever give on cross-examination. Isn't it true you didn't go to the home that day? Not exactly. Not exactly. Tell me more is what the judge is going to say to you at that point. Well, I actually did go to the home, but nobody was there. That's why you don't have any record of me being that. Or I didn't go to the home because I called 15 times and they said we're not going to be there. So those are little tricks that you can deal with cross-examination. Your comfort level, though, in testimony will determine how much you want to indulge the person who's cross-examining you. And then always remember, when cross-examination is over, the person who called you in the first place, the lawyer who's friendly to your case and your position, will get a chance to ask you more questions. It's called redirect. And so when it goes back to that lawyer will say, hey, a minute ago you testified this, but that wasn't the whole truth, was it? No, what exactly happened? Oh, well, let me tell you. And then after that is all done, other people get a chance to ask you questions. The judge may ask you questions. A lot of people can ask you questions. Take a deep breath. Give your best honest answer. That's really all anyone is ever looking for. Another big section to talk to when you're in the witness stand is how to deal with objections. It's actually simple for the witness, but in real time it's very difficult. A lot of times you're asked a question that you really want to answer, but before you're allowed to answer, another attorney will shout, objection, which is really one of the favorite things we like to do as lawyers. And sometimes we object for no good reason other than just to throw off the rhythm of a testimony. There are a lot of reasons why we object. Suffice it to say, when you hear the word objection, just stop. And then the lawyers and the judge will bicker a little bit because that's what we do. And then eventually the judge will either say overruled, which means you may answer the question, or sustained, which means you may not answer the question. Sometimes that conversation goes on for so long and the judge says overruled, you may answer the question, and you've completely forgotten what the question is. Very normal, very common. Just say, I'm sorry, I can't remember the question. Could you please repeat it? And the judge will either instruct the lawyer to ask it again or instruct the court reporter to read back the testimony, and that's perfectly fine. So there are two reasons why cases go to trial. Either somebody is wrong, or sometimes just needs to be heard, or just needs to cry or yell. And so when someone is wrong, the judge or the jury, in your case mostly the judge, will be the weigher of the evidence, as we talked about before. The judge will hear all of the evidence, will weigh your recommendations, and then decide whether you're right or whether you're wrong. You're right most of the time. Not all the time. None of us are. In other cases, sometimes it's just somebody who needs to get up on the witness stand and have their day. In those cases, you really shouldn't be testifying. And so my advice would be to speak to the lawyer who has subpoenaed you or has asked you to come testify in that situation and say, why am I going and why am I really on the witness stand? And you should get some insight as to why that's so, and hopefully that will make you feel a lot better. And sometimes you might even get excited and fired up to go and testify.
What can social workers do?
Well, for one, you can be prepared. That's one of the best things you can do for yourself. So prepare. Your job is really to gather, if you will, as much information and present it to the court. And it can be of great value there, great help. Also be objective. You're considered, if you will, to be a neutral investigator of the court. And that's really a very important role, right, that the social worker plays in an adult protective service case. You're also the expert. So the testimony is really an opportunity, if you will, to educate. And there are many opportunities that might arise. One that comes to mind offhand is, of course, the subject of undue influence. Not everybody understands that or how it's important in an APS case. And then lastly, and I think really, probably one of the most important, if not the, is to document. Because if it isn't written down, essentially, it didn't happen. So.
Yeah, I want to speak to that for a minute. The lawyers and the judge can see almost everything that you have prepared. Only your conversations with your lawyer and very certain confidential information cannot be revealed, but that's a very small percentage. And so one of the pieces of advice I want to give is you can prepare little cheat sheets for testimony, a lot of times chronology, when did you do what, and just a little page of what you did and when, perfectly fair. just remember that anything that you prepare, everyone gets to see.
Use your support. Talk to your county counsel, your supervisor, and coworkers. Keep the county counsel informed as things develop in your case. They get really irritated when you don't tell them everything that's going on. And understand the purpose of the hearing. Is it a criminal hearing? Is it conservatorship, contested conservatorship, or even termination of conservatorship? And like David said, tell the whole story.
So preparation is really everything in terms of providing testimony. So, of course, before you go into any situation involving the court, take time to know your case and know your facts. Pre-meet, if you will, with county counsel or who's ever advising you, as well as your supervisor. It's also really important in terms of dressing, right?
Mm-hmm. Yeah. David, can you speak to that?
Sure. You, as a witness, everyone will be weighing, especially the judge and the fact finders, will weigh your credibility. In other words, sometimes it's not even so much what you say, it's how you say it. And judges notice in the same way that you may be sitting in a room and you, as the professional, are noticing what people wear, the nonverbal communication, all of those things. We're doing the same. The judges and the lawyers are weighing your credibility based on what you're wearing and how you're saying it. The more confident that you are, the more relaxed you are, and the more in touch you are with your case, and the more prepared you are, the better your testimony is going to seem, and the more you're going to enjoy it. Also, sometimes I advise folks, especially if you're particularly nervous, bring something up to the stand with you that maybe you can put in your pocket that you can just hold on to if you're feeling particularly anxious. I remember once one of your colleagues was a ballerina, and so she had a little keychain with ballet slippers, and she was very nervous about testifying, which struck me as odd because she's very used to being on stage and performing and doing things that are much harder than talking about what they already know. But she brought the little keychain with the ballet slippers up with her, and she was able to testify. And afterwards, she emailed me and said, yeah, it really was a very fun experience, and she really actually enjoyed being able to talk about what she knew, which she knew better than anyone, with everybody in the court.
Great. Are you saying that we should leave our shorts and sandals and sleeveless wear in our home closets?
No, unless the judge is wearing shorts and sandals and sleeveless wear, which is extremely rare. Once in a while, you'll get somebody who will really appreciate that. Know your judge, know your lawyers, be prepared for who you're going to be in front of. And if you're going to be prepared in front of someone who's going to be dressing a certain way, make sure you match that.
Great, thanks.
Yeah, and it's also really important, right, to remember that the judge can see everything that's going on. Mm-hmm. So, and if there's a jury, they can see it as well. So it's best to refrain from laughing, from sighing, from eye rolling, from chewing gum, things that can distract. Talk slowly and clearly and loudly so that people, really can comprehend what you're saying. Only answer the question that is being asked. I think sometimes when in social work we're compelled to give a little more information, and that's not what we should be doing. So listen to the question and then pause and maybe take a deep breath, as you were saying, David, right? And give your best honest answer. Correct any mistakes.
Yeah, please don't try to read anyone's mind, especially in direct.
Yeah.
When the person who's calling you as a witness is talking with you, he or she is going to know what information they want you to say, even though it's going to feel like a coffee shop conversation. Don't ever think to yourself, boy, I wonder if he's asking me to talk about this, or, I'd really like to talk about that. That's really, just listen to the question, give your best honest answer directly. If you're talking about things that don't relate to the question, or if you get into things like hearsay, which is what other people are doing or saying, someone's going to cut you off, and it's going to impact your own credibility. So listen to the question, give your best honest answer.
Great. So what you're saying is we need to stop talking if an objection is made. If we don't know the answer, say we don't know the answer. Or what else did you say?
Remember to breathe.
Right.
Very important. And you may think when you're sitting on the witness stand that deep breath you're taking is taking forever and everybody's watching you and the spotlight is on you and the lights are going and the cameras are on. None of that is happening. Take that deep breath. It's a moment in time. It will allow yourself to be grounded, and it will give you the ability to give the answer that is needed.
Body language, again, a little bit more about body language, really trying to exude that confidence, right? And to appear relaxed, stay alert. Avoiding indicators of untrustworthiness, such as like touching your hands and clasping them together and touching your face and crossing your arms. It looks like you're holding back something. And sit up straight. One of the first things people notice is your posture. So again, be honest and be congruent in what you're saying.
Please be honest. That's really important. If the answer is, I'm not sure, say, I'm not sure. If the answer is, I don't know, say, I don't know. If you don't understand the question, your answer is, I'm not sure I understood your question.
Great.
And to that extent, also don't sound defensive, right? So even if the cross-examination questions seem worded to make it sound like you made a mistake, just calmly state the facts as you know them. Also keep your voice even and avoid using emotion in your words, your tone of voice, and your demeanor. And then, of course, direct your answers to the judge as much as you possibly can during a court trial, and to the jury, of course, during a jury trial. It really promotes your credibility in the courtroom.
We have an old saying in the law, if the law is on your side, argue the law. If the facts are on your side, argue the facts. If you don't have the law or the facts, pound the table. And sometimes that's what lawyers are trying to do with you. They're just trying to get you agitated or riled for no other reason than they have a paying client sitting next to them, or they have a difficult client sitting next to them. If you are prepared and if you understand why you are there and what your case is all about, you're going to be just fine.
Thanks. Good luck.